Welcome to Planning Ahead with CMS. Welcome to this important special episode of Planning Ahead with CMS. A judgement has recently been issued by the Supreme Court in the Hillside Parks case. This has significant implications for our developer clients who are considering using or have in the past used drop-in or slot-in planning permissions. These are sometimes used to make changes to an existing development. The Supreme Court upheld the judgment of the Court of Appeal. In summary, it is unlawful to develop a site pursuant to a planning permission which it is physically impossible to concurrently deliver development pursuant to. However, the Supreme Court's judgment did include some commentary which is very helpful to our development clients. Charles Casey acted for the Hillside Parks Ltd and has kindly agreed to join us today to discuss the implications of the Hillside judgment. Welcome, Charlie.
Thank you very much indeed.
Now, one of the hardest things about Hillside is working out how we're going to apply it in the real world. So we're going to start off with a real test, which is considering some sort of real life development scenarios that our team have designed and which apply to our clients to apply the judgment. So the first one, we're going to be thinking about situations where you're going to go about implementing two or more planning permissions at the same time. So you've got two planning permissions for the same site. You don't want either of them to expire. So you're going to try and do some works to implement the development. So the first scenario is if you carry out implementation works pursuant to planning permission A and implementation works pursuant to planning permission B, but both of those sets of works are covered by both planning permissions, so there's no inconsistency. Do you think that following Hillside, we can keep both planning permissions alive in that scenario?
Yes, I do. I think one of the challenges in that scenario is to evidence that you have actually implemented both, because if the works could be lawful under either permission, you'd want to make sure that you convince the local planning authority that you relied upon both of them as opposed to one rather than the other. But that's not really a Hillside point, that's more about commencement and implementation. But subject to that, if there's no inconsistency between the two permissions, then there isn't a Hillside issue that arises, or Pilkington issue that arises. Even actually if there were, it would have to be the case that implementing one of them meant the development authorised by the other was physically impossible. And the Supreme Court was at pains to emphasise that that meant something more than simple inconsistency. So if, for example, there was a condition on one permission requiring the retention of some trees, and the development under later permission involved removing those trees, that would still mean the development under the first permission was physically possible, even if there was some inconsistency around the edges. So I think the example you give is unlikely to give rise to problems under Hillside.
This is one that came up from Josh Rizzo-Gill in our team, where you do implementation works pursuant to both planning permissions. Now, you're not doing the same works to implement both. And the works you do pursuant to the second planning permission are material enough to satisfy the test for having implemented the development, but are minor enough that you could have gone about authorising those works by making a Section 96A application to the first planning permission. In that situation, where do you think we sit with Hillside?
So provided that they are and are accepted by the local authority, non-material, that ought to be okay too. And the reason for that is the Supreme Court in the Hillside judgment made clear that even if implementing a permission B meant that the full development authorised by permission A was physically impossible, if it was a non-material physical impossibility, that didn't matter. That didn't lose the ability to rely upon the first permission. And they didn't expressly say that test was the same as a Section 96 NMA, but the very next paragraph goes on to talk about Section 96A. So I think they had in mind that the boundaries of a non-material physical impossibility were the same as an NMA. The only risk factor I think in that scenario is whether the local authority agrees, because whether a a departure is material or not is ultimately a question of planning judgment. And if the local authority disagrees, then it may be quite difficult to challenge their stance on an application for judicial or statutory review.
See, in my mind, that's one of the key sort of nice nuggets that have come out of the Supreme Court judgment, because I wouldn't have been comfortable giving my clients advice that they could have done that following the judgment in the Court of Appeal. So that's a one for the developers.
Yes, absolutely. Yes, the High Court, there was a part of the High Court that the park didn't cross appeal, where the first instance judge said that the pre-1987 planning permissions in the Hillside case didn't, their implementation didn't of themselves lose the developer's ability to rely on the original consent because the departures weren't substantial. Now that wasn't actually ever cross-appealed into the Court of Appeal, so the Court of Appeal's judgment doesn't explore that. I think the Supreme Court's reference to non-material physical impossibilities is channeling the kinds of consideration that the High Court had in mind.
So then our final situation, and I think this one's quite an easy one, is if we carry out material works under the new permission, possibly even a whole block or phase that's inconsistent with the earlier permission, but on a piece of land that's out with the planning permission that was granted for the first bit. What do you think about that situation?
Well, I think if it's outside the red line, but there's some other inconsistency, so whether it's in breach of some condition or something else, something that's regulating the original consent, that's unlikely to be a concern, provided that, and this is sort of the key aspect of judgment, that the first consent, the development authorised it, is still physically possible. That scenario you've described sounds to me a little bit like that tree preservation example I gave, and there's a judgment from some years ago looking at that precise point. So there's an inconsistency, but the first development is still physically possible despite that inconsistency. So that ought not to preclude the ability to rely on the first permission.
For the law geeks watching, the tree case is Prestige Homes.
That is absolutely Malcolm Spence.
Excellent. So now I can move on to a second line of questioning, thankfully not a problem question this time. And this one's from Martin Evans. Many people will have heard about the Lucas case and the idea that you could have independent acts of development pursuant to a planning permission. And when you have them, that means that you can still do drop-ins, happy days. But the Court of Appeal said some pretty bad things about Lucas, and the Supreme Court were much more positive, in my opinion. But there was kind of a little glint of light, which suggested that if we were very clear on the face of the planning permission that that's what we were doing, then it might be okay. How far do we need to go? What do you think we need to do to put that into effect?
So I think we need the clearest possible words. It was quite obvious that the Supreme Court was not going to be convinced by considerations of convenience. They were unlikely to make inferences in the developer's favour in this sort of context. So I think the express words are needed. They actually said that, I think it's paragraph 68, where they said in terms to make a planning permission a Lucas type permission where elements of the authorised development were severable, you would need express words. And why does that matter? It matters because if a development is properly analysed as is properly analysed as authorising severable components, then if there's a Pilkington issue in relation to one of those components, so part of that development is no longer physically possible to build out, then that Pilkington issue may effectively extinguish that aspect of the permission, but the rest is still able to survive. So in other words, you look at Pilkington through the prism of each individual severable element. So that's the value of a severable consent. My own view is I think you would probably have to have the express words in the description of development. I get asked from time to time, could you do it through a phasing condition? Could you do it through a section 106? Definitely not a 106 because that's not part of the permission, it just regulates it. Conditions are part of a permission, but really they carve down from what's the description of development otherwise authorises. So I think it needs to be in the description. I think the gold standard is likely to be words along the lines of, to take an easy example of a 500 home residential development, outline planning permission for up to, and those words are going to be important, up to 500 homes, and let's say a retail store comprised of the following 6 individual, severable and self-contained elements. And then you would Roman numeral list them 1, 2, 3, 4, 5 and 6. Now it might be said having the words self-contained, individual and severable is repetitive, and obviously it is, but I think certainly for the first test case, and no one wants their development to be the test case, you want the absolute clearest possible word so there's no scope for a court to wriggle out of it.
I don't think that's overkill at all. I actually thought you might go as far as saying we needed to use the phrase independent acts of development as well.
Yes. Well, that's another way of, absolutely another way of looking. I think you definitely want to get the S word in. You definitely want to get the word severable in, and then independent, self-contained, individual, additional words to beef up what's actually meant. And I think a numbered list conceptually helps as well. So none of those elements may necessarily be essential, but you want to be err on the side of inclusion until there's some guidance, further guidance from the courts in due course.
Cool. Thank you very much.
Pleasure. Thank you.